If a motorist negligently collides with an ambulance carrying a dying patient, resulting in the patient's death, can the motorist be held liable in a wrongful death action? What if expert testimony revealed that the patient was almost certainly to die en route to the hospital? The 1911 New York case of McCahill v. New York Transportation Company examines a similar scenario in the context of an alcoholic dying from an extreme form of alcohol withdrawal. One night in Manhattan, a man was struck by a New York Transportation Company taxicab and thrown approximately 20 feet, breaking his thigh bone and injuring his knee. He was immediately rendered unconscious and taken to the hospital. He died the next day of delirium tremens, a serious and fatal form of alcohol withdrawal. The victim was an alcoholic, and the injuries he sustained couldn't have resulted in delirium tremens if he didn't already suffer from a pre-existing alcoholic condition. The victim's family brought a wrongful death action against the cab company in trial court. At trial, a physician testified that the victim's injuries precipitated his attack of delirium tremens, but didn't induce it. The jury determined that the cab company was negligent and that the victim wasn't contributory negligent. The cab company appealed, contending that its driver's negligence wasn't the proximate cause of the victim's death, which also wouldn't have occurred if the victim didn't suffer from alcoholism.